Imagine your father passes away. There's land, a house, some savings, and someone in the family tells you you have no right to any of this because you're a daughter. Would you believe them? Hi everyone, I'm Rakshita Virle, and today I'll be discussing Hindu female succession rights and under the Hindu Succession Act 1956. Interestingly, this situation was not hypothetical. For a long term in India, daughters were actually excluded from inheritance in joint family property. The Hindu Succession Act of 1956 attempted to correct this inequality, and later the 2005 amendment brought one of the most important reforms in property law. In the next few minutes, we'll look at how the law evolved from exclusion of women to recognizing daughters as equal coparceners. Before 1956, Hindu succession was mainly governed by two classical schools of law, Mitakshara and Dayabhaga. Under these systems, inheritance largely revolved around male lineage. Women were generally not considered part of the chain of coparcenary ownership. Sons acquired rights in ancestral property by birth, but daughters did not. At best, women could receive property through stridhan, gifts, or maintenance arrangements. Even when property came to them, their rights were restricted. They were considered limited owners, meaning they could use the property but could not freely transfer or dispose of it. This system effectively kept women outside the economic structure of family property. Because of these inequalities, the legislature introduced the Hindu Succession Act 1956 to reform Hindu inheritance law. One of the most revolutionary provisions of the Act is Section 14. Section 14 transformed the nature of property ownership for Hindu women. Before this provision, women held property mostly as limited owners. Section 14 changed that by declaring that any property possessed by a Hindu female, whether acquired before or after the Act, becomes her absolute property. This means the woman has full ownership rights. She can sell it, gift it, transfer it, or dispose of it through a will. The objective was to eliminate the concept of the limited estate and recognize women as independent property holders, not merely custodians of property. This provision was an important step towards economic empowerment of women within the family structure. Another major reform came through the 2005 amendment to Section 6 of the Hindu Succession Act. Originally, under Mitakshara law, only male members of the joint Hindu family could be coparceners. The 2005 amendment changed this completely. It provided that a daughter shall be a coparcener by birth in the same manner as a son. This means daughters now have equal rights in ancestral property. Secondly, equal liability in family obligations. Thirdly, the right to demand partition of property. In simple terms, the law protected and placed daughters and sons on the same legal footing in joint family property. This amendment marked a major shift toward gender equality in inheritance law. Apart from coparcenary rights, the Act also lays down rules for interstate succession, meaning when a person dies without leaving a will. Under Section 8, the property of a Hindu male dying intestate is distributed among Class 1 heirs. These heirs include the widow, son, daughter, and mother, all of whom inherit simultaneously and equally. Sections 15 and 16 deal with succession to the property of a Hindu female. Generally, the property of a Hindu woman devolves first upon her children and husband, then upon the heirs of the husband, and thereafter upon her own parental heirs. These provisions create a structured order of succession for female property. To summarize, earlier Hindu property law largely excluded women from inheritance. The Hindu Succession Act 1956 introduced reforms such as full ownership of property under Section 14. Later, the 2005 amendment to Section 6 recognized daughters as co-partners by birth, granting them equal rights in ancestral property. Finally, judicial interpretation, especially in Vinita Sharma versus Rakesh Sharma, clarified that daughters' coparcenary rights exist regardless of whether the father was alive in 2005 amendment. These developments reflect a gradual but significant shift towards gender equality in property rights within Hindu law. Thank you.